Virtual Lesson 5.2 International Organizations. The rise of international organizations. International organizations serve many useful purposes, so they developed naturally as advancements in telecommunication and world travel made them possible. They are now essential elements in the administration and enforcement of international law. Many of these organizations are made up of representatives of the governments of the participating nations. Some of the most well-known are agencies of the United Nations, such as the General Assembly, the Security Council, and the International Court of Justice. These types of international organizations are sometimes referred to as intergovernmental organizations or international governmental organizations, or IGOs. Many other international organizations are non-governmental organizations, or NGOs, such as the Red Cross, Amnesty International, Doctors Without Borders, Greenpeace, and the International Olympic Committee. The League of Nations. When the United States entered World War I in 1917, President Woodrow Wilson was horrified by the brutality and death that had been taking place. He later suggested that an international organization would be necessary to prevent similar catastrophes in the future by promoting communication, cooperation, the reduction of arms, and collective security, which meant that if any member of the organization fell under attack, the other members would come to their defense. With the signing of the Treaty of Versailles in 1919 to end the First World War, the League of Nations was created to achieve those goals. The League eventually grew to include 57 member states, but ironically, the United States never signed on. The main bodies of the League of Nations were the Council, made up of permanent members such as France and the UK, as well as non-permanent members, and the Assembly, with representatives from all member states. These were both functioning forums for discussion. However, a unanimous decision had to be reached before any action could be taken, a requirement that lessened their effectiveness. The League established autonomous agencies for political purposes, such as the Permanent Court of International Justice, predecessor to the current International Court of Justice, and the International Labour Organization, or ILO, which is still operating today in association with the United Nations to promote social justice as well as internationally recognized labor and human rights. The League also created subsidiaries with non-political goals related to the economy, health, and social concerns. Despite its good intentions, the League of Nations was unable to prevent the outbreak of World War II. This was for many reasons, probably the most important of which was the fact that 3 pivotal countries were not members. Germany was not allowed to join after being held responsible for starting World War I. Russia was not allowed to join out of fear of the possible spread of its communist influence, and the United States was unable to ratify its membership at home. In addition, the League of Nations did not have its own armed forces and did not have the right to compel military actions from any of its members. Overall, the League had little ability to enforce its mandate on a large scale. In 1946, after the end of the Second World War, the League of Nations was dissolved, with many of its structures being absorbed into its successor, the United Nations. The United Nations. While the Second World War was being fought, representatives from the UK, the United States, the former Soviet Union, and China were in discussions to create the framework of an international organization that would be more effective than the League of Nations in maintaining post-war peace. Near the end of the war in 1945, 50 nations sent delegates to San Francisco to draft the Charter of the United Nations. Since then, almost every other state on the planet has become a member. The only notable exceptions are Taiwan, excluded due to the objections of China, which claims it as part of its own territory, and the Vatican, due to its unique status as a city-state within Italy. The Charter of the United Nations includes specific statements of the founding principles of the UN, including the prohibition of the threat or use of force against another member and the goals of maintaining international peace and security, developing friendly relations among nations, solving international problems, and promoting respect for human rights. The United Nations includes 6 major institutions. 5 of them are based at the UN headquarters in New York City. These are the General Assembly, the Security Council, the Secretariat, the Economic and Social Council, and the Trusteeship Council. The 6th institution, the International Court of Justice, is located at The Hague, Netherlands. The General Assembly. The General Assembly of the United Nations is the arena for representatives of all member states to discuss, debate, and strive for consensus on global issues. It functions with a one nation, one vote formula, meaning that even the smallest of countries have a meaningful voice. In most cases, the General Assembly adopts resolutions as opposed to imposing legally binding laws or regulations. However, since the resolutions carry the weight of international consensus, they are an effective means of establishing norms for the international legal system. In other words, accepted customary standards or practices. Legal norms are prescribed either by a specific subcommittee of the General Assembly or by the International Law Commission, or ILC, a think tank established by the UN in 1947 to solve problems and promote the codification of international law. The Security Council. The Security Council is responsible for maintaining peaceful relations and security and, in contrast with the General Assembly and all other bodies of the UN, has the power to make decisions that are legally binding on any or all members of the United Nations. Its decisions may then be enforced by the levying of sanctions against states that are in contravention of Council orders. For this reason, it is the most powerful division of the UN. The UN is well known for its ongoing peacekeeping operations in various locations throughout the world, and these operations are supervised by the Security Council. Canada has played a significant role in many of these operations and enjoys a good reputation as a peacekeeping nation. The Security Council is comprised of 15 members, including 5 permanent members, which were the victors of World War II: the US, the UK, France, China, and Russia, and 10 non-permanent members, which are elected for 2-year terms by the General Assembly. The non-permanent members represent geographic regions as follows: 5 from Africa, Asia, and the Middle East, 2 from the West, 2 from Latin America, and 1 from Eastern Europe. Winning non-permanent member status provides an opportunity for other nations to gain recognition on the world stage, both for their capabilities and for the particular issues that they consider important. Chapter 6 of the UN Charter grants investigative powers to the Security Council, and Chapter 7 empowers it to denounce acts of aggression or any other violations of the UN Charter, and to take action, including the use of force if necessary. An important example occurred in 1990 when the Security Council authorized the use of force against Iraq after it had invaded and annexed Kuwait to increase its oil holdings. The US-led UN forces then successfully freed Kuwait by pushing the Iraqi forces out. Any significant proposal must pass with a strong majority of 9 votes before a resolution or any action is taken, and each of the 5 permanent members holds a veto power. This means that all 5 permanent members must either support or abstain from voting on each Security Council resolution that is passed. Members of the Security Council are also responsible for serving on permanent standing committees or temporary ad hoc committees, the latter of which are sometimes formed to administer sanctions. Some well-known ad hoc committees are the United Nations Compensation Commission, formed to administer reparations to be paid by Iraq to Kuwait after the invasion of 1990, the war crimes tribunals that were necessitated by the atrocities committed in the former Yugoslavia and Rwanda, and the United Nations Monitoring, Verification, and Inspection Commission, formed to monitor Iraq's destruction of its weapons before and after the Second Gulf War in 2003. The Secretariat. The Secretariat is the administrative body of the United Nations and is headed by the Secretary General. currently Ban Ki-moon of South Korea. Other recent Secretaries General were Kofi Annan of Ghana from 1997 to 2006 and Boutros Boutros-Ghali of Egypt from 1992 to 1996. The Secretary General is appointed by the General Assembly on the recommendation of the Security Council for a renewable 5-year term. The Secretariat is responsible for the day-to-day operations of the UN, overseeing the implementation of programs and policies such as peacekeeping, the mediation of international disputes, and the administration of surveys of economic and social trends or studies of important issues such as human rights and the environment. It is important that the employees of the Secretariat are able to act freely in the exercise of their duties, so they take an oath to not seek or receive instructions from any government or outside authority. They must answer only to the United Nations. The Economic and Social Council. The Economic and Social Council has been increasing in importance as the focus of the UN shifts toward economic, human rights, and social issues. It is responsible for coordinating the economic and social work of the United Nations, as well as overseeing a number of NGOs that report to the UN, such as UNICEF. It also oversees the International Labour Organization, or ILO. There are 54 seats on the Economic and Social Council, which are allocated geographically. The Trusteeship Council. The Trusteeship Council is responsible for supervising territories under the control of the International Trusteeship System, which in 1945 included former colonies of the defeated Axis powers, Germany, Italy, and Japan, as well as other territories that had been under the mandate of the soon-to-be-dissolved League of Nations. The main goals of the Trusteeship Council were the development of the societies which it oversaw, by improving quality of life and supporting the transition towards self-government and independence. The last territory under the stewardship of the Council to gain independence was Palau, which became a member state of the United Nations in 1994. At that point, the Trusteeship Council suspended its operations, and although it still exists as prescribed by Chapter 13 of the UN Charter, it remains inactive. Criticisms of the United Nations. The UN is the primary organization charged with promoting world peace and security. However, it is often criticized for its reactionary approach, taking action on an ad hoc basis to address existing problems, as opposed to a more proactive, big-picture approach, whereby it would base its actions on a comprehensive understanding of world issues with the aim of preventing problems or addressing them before they become serious. The difficulty with taking this type of proactive approach is that it would require far more human and financial resources than are currently available. Other criticisms of the UN are directed at the representativeness of the Security Council. Some argue that the geographical allocations are based on the post-war world and do not properly reflect the current situation. Some argue against the status of the 5 permanent members. Is it fair that so many resolutions fail to pass due to the veto power of a single nation? The appropriateness of the current list of permanent members is also the subject of debate. For example, does France have more entitlement to that status today than Germany or Japan? The International Court of Justice. The International Court of Justice, or ICJ, also known as the World Court, is made up of 15 judges, elected by both the General Assembly and the Security Council to 9-year terms. They are formally judges or lawmakers in their home countries, but once elected to the World Court, they are to no longer have ties to any particular country. Every 3 years, elections are held to fill 3 of the seats, and the composition of the court, at any given time, must not include more than 1 judge from a single country. The ICJ operates under a separate statute that forms part of the UN Charter, and it serves 2 main purposes: to settle disputes between nations and to provide advisory opinions on questions of international law that are referred to it by the UN and its agencies. Disputes between nations may be brought before the ICJ if each party agrees to its jurisdiction, or by a unilateral application by one of the parties. In some cases, a country may make a declaration that it agrees in advance to be subject to the jurisdiction of the ICJ for certain types or all legal disputes in which it is involved. This is referred to as compulsory jurisdiction. In a controversial move in 1985, President Ronald Reagan withdrew the acceptance by the United States of compulsory jurisdiction and now decides to subject itself to the jurisdiction of the World Court on a case-by-case basis. Canada is one of the 66 countries that currently accept the compulsory jurisdiction of the ICJ. Parties who properly fall under the jurisdiction of the ICJ must abide by its decisions, and Article 94 of the UN Charter makes judgments enforceable by the Security Council when necessary. This means that if a party to a case decided by the ICJ fails to comply with its orders, the Security Council can take measures to compel compliance. Cases decided by the World Court have included disputes over territorial sovereignty with respect to both land and maritime boundaries, and its advisory opinions have dealt with human rights violations, the legality of the threat or use of nuclear weapons, and UN membership. A quorum of 9 judges is required to render a decision or an opinion, but typically all 15 judges are in attendance, as the caseload has historically been light. Some cases, though, may still take years to resolve. Since the ICJ is set up only to consider matters between states, no individual, corporation, or NGO may be a party to a case before it. However, through lobbying, an affected entity may be able to influence their government to take up the cause on their behalf. If a nation involved in a matter before the ICJ does not have a representative among the 15 judges, then an ad hoc judge will be appointed to join the court for the hearing of that case. International human rights. At the core, there is natural tension between the concepts of inalienable human rights and state sovereignty. Historically, governments have opposed the idea that the rights of its citizens should derive from international norms as opposed to state policies. However, over time, and especially after the devastating international events of the World Wars and the Great Depression, the belief that human rights are natural and inalienable has become more and more accepted across the globe. The first official recognition of international norms for individual human rights was contained in the UN's Universal Declaration of Human Rights, or UDHR, which was adopted in 1948. The UDHR, being a UN resolution, carried limited weight, especially when it came to enforcement. To amplify its effect, the UN also drafted 2 treaties intended to be ratified by the governments of individual countries, thus assuming the force and effect of international law. The International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights have so far been ratified by a great majority of nations, and together with the UDHR, form the International Bill of Rights. There are many other UN treaties related to human rights that have more specific aims, such as the Convention on the Rights of the Child and the Declaration on the Rights of Disabled Persons. Canada's performance with respect to each treaty to which it has agreed is regularly reviewed by UN committees. As an example, the International Labour Organization found that back-to-work legislation that was passed by the Ontario government to end strikes and lockouts in 8 school boards in 1998 violated the Freedom of Association and Protection of the Rights to Organize Convention. Conflicting views of human rights. It is important to note that although almost all nations have indicated a desire to codify and protect inalienable human rights, and although most nations have ratified the UN's human rights treaties, beliefs about the actual content and relative weighting of human rights varies greatly. The UN documents were heavily influenced by Western philosophy. In some other parts of the world, however, the majority of the people prefer to adhere to other philosophies based on their religions or cultural norms. For example, cultures vary greatly with respect to their views toward the relative roles and status of men and women in society. Freedom of religion, which is a fundamental human right in many Western societies, conflicts with the Islamic doctrine that forbids changing religions. Also, many African cultures place less emphasis on individual rights and more emphasis on family and community obligations. Critics of Western society would argue that our extreme focus on individualism is one of our greatest problems. Evidence of differing philosophies is found in the fact that many countries and regions have created their own codes of human rights since the adoption of the UDHR in 1948. Canada, of course, has the Canadian Charter of Rights and Freedoms, as well as the provincial human rights codes. In 1950, Europe expressed its views with the European Convention for the Protection of Human Rights and Fundamental Freedoms. And in 1982, African nations worked together to create the African Charter of Human and People's Rights. Regional and specialized organizations. There are numerous organizations outside of the United Nations that impact international law. Their mandates are generally outside the scope of the UN due to their localized or specialized natures. Following are summaries of some of these organizations that are of particular interest to Canada. Asia-Pacific Economic Cooperation, or APEC. The APEC Forum includes 21 member states from 4 different continents: Asia, North America, South America, and Australia. It arose out of the desire to improve trade among Pacific Rim nations in light of the fact that trading blocs were forming elsewhere in the world with NAFTA and the European Union. APEC is primarily focused on trade and economics, but has also recently turned its attention toward environmental and women's issues. North American Free Trade Agreement, or NAFTA. NAFTA is a trilateral agreement among Canada, the United States, and Mexico that came into effect in 1994. Its main focus is the development of the economies and trade among the 3 member nations, but it also covers other issues such as labor and environmental concerns. Organization of American States, or OAS. The OAS was founded in 1948 with its headquarters in Washington, D.C. Canada did not join immediately due to concerns about conflicting positions with the U.S. on some issues such as relations with Cuba. Canada became a member in 1990, and the OAS now includes all 35 independent nations from North, Central, and South America. The OAS focuses on many issues, including the promotion of democracy, human rights, poverty, peace and security, trade, and complex problems such as the drug trade and government corruption. The Arctic Council. The Arctic Council was launched in 1996 as an organization of the 8 nations that border the Arctic Ocean, as well as indigenous groups such as the Inuit Circumpolar Conference. Non-Arctic countries and NGOs may also participate in the Council as observers. The Arctic Council was set up to improve cooperation, coordination, and interaction among the member states as they work to address issues related to Arctic shipping routes, climate change, oil and gas resources, sustainable development, and environmental protection. L'Agence intergouvernementale de la francophonie, or La Francophonie. La Francophonie was created in 1970 and is now comprised of 50 members from different levels of government of French-speaking areas, including Canada-Quebec and Canada-New Brunswick. It focuses on cultural, educational, and political issues of concern to French-speaking peoples. The Group of 8, or G8. The G8 is made up of 8 countries with democratic ideals and economies that are among the largest of the world. The 6 founding members as of 1975, Britain, France, Germany, Italy, Japan, and the United States, Canada, which joined in 1976, and Russia, which joined in 1998. The purpose of the original meeting in 1975 was to discuss the increasing oil prices that were destabilizing the global monetary system. Since then, topics of discussion have included economic management, trade, issues with developing countries such as the AIDS crisis in Africa, the environment, the drug trade, terrorism, and human rights. In recent years, the annual G8 summits have made as many headlines for their anti-globalization demonstrations as for the issues that have been tabled for discussion. North Atlantic Treaty Organization, or NATO. NATO is an alliance of 28 countries from North America and Europe, headquartered at Brussels, Belgium, and dedicated to fulfilling the goals of the North Atlantic Treaty, signed in 1949. Traditionally, this has involved political and military measures to safeguard the security and freedom of its member states, but more recently, its scope has expanded to include peacekeeping and anti-terrorism activities. Examples include NATO's intervention in the Serbian-Albanian conflict in Kosovo in 1998, about which there were grave humanitarian concerns. The UN Security Council was unable to act due to a lack of support from two permanent members, China and Russia. NATO then resolved to act by bombing Serbian targets and later to help restore peace in Kosovo. After the terrorist attacks of September 11, 2001, NATO declared that they had been attacks against all NATO countries and subsequently acted to assist the US in its campaign against terrorism. The Organization for Economic Cooperation and Development, or OECD. The OECD was established in 1961 and has since grown to include membership by 34 countries with its headquarters in Paris. The main goal of the OECD is to coordinate domestic and international business policies in an attempt to achieve consistency in light of ever-increasing globalization. The Organization for Security and Cooperation in Europe, or OSCE. The OSCE was founded in 1973 and has since grown to include membership by 56 countries from North America, Europe, and Asia, with its headquarters in Vienna, Austria. It was created in response to Cold War tensions and is the world's largest international security organization, with a mandate that includes early warning of military action, conflict prevention, crisis management, and post-conflict rehabilitation. The International Joint Commission, or IJC. The IJC is a binational organization created in 1909 by the Boundary Waters Treaty between Canada and the United States. It has an environmental mandate, which today includes concerns related to the quality of the bodies of water at the border between the two countries, such as the Great Lakes, as well as air quality. The North American Aerospace Defense Command, or NORAD. NORAD is another binational organization of Canada and the United States, formed in 1958 to provide an organized system of continental defense. International Regulation of Corporate and Individual Behavior. Guidelines, Regulations, and Standards. The international organizations and international law that we have examined so far have generally been created to regulate states and state actions. However, it is also sometimes important for international law to address the actions of individuals or corporations. A number of international organizations have put forth guidelines, regulations, or standards in an attempt to control corporate behavior with respect to many important issues, such as bribery and corruption, child labor, human rights, fisheries, the safety of food products, and the handling of hazardous materials. As international law, these regulations may be hard to enforce in some circumstances. They may, however, serve as blueprints as individual countries draft domestic legislation that will have a more direct impact. Interpol. Interpol is the world's police organization. With a membership of 188 countries, it is the second most global international organization after the UN. International law requires individual countries to enact and enforce laws to control crimes with international implications, such as terrorism, drug trafficking, arms trafficking, traffic in persons, and obscene publications. Interpol coordinates and assists the national police forces when international issues arise. International Criminal Tribunals. International criminal tribunals are formed to try individuals for gross violations of human rights, such as genocide or crimes against humanity. Early examples included the Nuremberg and Tokyo tribunals set up after World War II, when details of atrocities committed during the war were made known. Tribunals currently in operation include those set up to deal with crimes committed during the civil wars in Rwanda and the former Yugoslavia. The International Criminal Court, or ICC. The ICC was established in 2002 after 60 countries ratified the Rome Statute of the International Criminal Court. The mandate of the ICC is to deal with serious criminal charges laid against individuals, similar to international criminal tribunals, but on a broader and ongoing basis. Concerns exist due to the relatively low number of countries that have ratified the Rome Statute. A number of powerful nations, including the United States, Russia, China, and India, have not yet ratified the statute for various reasons. This piecemeal participation in the ICC may lead to jurisdictional issues that hamper the success of the court.